Mr. Gaines, and I, along with Jonathan Cooper and Autumn Bowling, represent Mr. Kade Abbott. This is a direct appeal from the Circuit Court of Blount County, Tennessee, and I can tell you it's purely on a sentencing issue. And in fact, similar to the recent case that part of this panel ruled on recently, the Frazier case, it's similar to that case in that it discusses 40-5-103B. Let me start with the end for a second. The last page of the ruling by the trial court in this case denying Mr. Abbott probation is this: I cannot in good faith depreciate the seriousness of the sexual battery by a teacher at a school function after months of inappropriate relationship. It just weighs too heavy. It does. In good faith, the trial court said. How did we get here? How did this happen? Mr. Abbott was charged with 3 counts of sexual battery by an authority figure, Class C felonies. Now, Mr. Abbott had a trial lawyer that didn't negotiate a reduction of those charges. In fact, what the negotiated deal was for the plea was that Mr. Abbott would plead to sexual battery by an authority figure. Mr. Abbott did not depreciate the seriousness of the offenses. He pled as charged. His conduct was he was a school teacher in a school, and he had out of clothing and kissing of a 14-year-old student at the school, and some allegation of maybe touching of the breasts. That's what he was charged with. That's what he pled to. 3 counts, C felonies. Mr. Abbott has no prior criminal history whatsoever. No charges, no convictions, nothing. Mr. Abbott, during the time period awaiting sentencing, approximately 20 months, was on pretrial. The pretrial included an ankle bracelet. He's in Mississippi. He has to report to pretrial in Blount County and to court in Blount County every time for over 20 months.
And
he does so.
Didn't the trial court acknowledge and weigh those factors in the sentencing? I mean, I know it was argued, but as I recall, the trial court recognized those positive factors, but weighed them against the other factors, and which is what the trial court does, and denied probation.
Well, Your Honor, I'd like to go through the analysis a little bit, but I don't believe the trial court ever really weighed them. She goes through the factors that are favorable to Mr. Abbott in the beginning of, say, page 77 on is her ruling. She goes through those reasons. She finds he's eligible for probation under the statute. Then the burden's on the probationer or the defendant to find that he's also favorable for probation. And I think what I'm trying to say is there's a marked contrast between Mr. Abbott's clear favorable for probation status. He is an almost perfect candidate. You know, I know in Frazier you talked about the strong R and the psychosexual, but in here we have a moderate to low risk here too for the same reasons. And I think Dr. Adler in the psychosexual analysis says he's amenable to treatment, and if he gets treatment, he's actually a low risk. So to answer your question, yes, she acknowledges those things to Mr. Abbott, which makes actually the ruling she does even worse, because that analysis isn't really done. She acknowledges those. She never finds that he's favorable for probation. What she does is, as she finishes up the discussion that Judge Ayers was just talking about in the transcript, she begins an analysis on page 88 that is baffling, yet I think I know what she's doing. She is saying that this crime, the next thing I should consider the offense, is particularly enormous, gross, or heinous. This court and the Supreme Court has used different language for the Trent Trotter standard for using depreciation and seriousness of the offense as the only factor to decide someone's denial of probation. So this is what she's doing. She's analyzing whether the Trotter-Trent factors are present in the depreciation of the seriousness of the offense. And bewilderingly, she says, the law says is especially gross or heinous, but based upon the definitions in the law that's been provided and that I've reviewed, I cannot make that finding. So the question is, okay, she's gone ahead and gone to 40-5-103B, because clearly in this case, A and C don't apply to Mr. Abbott. She's gone to B, and she's gone to depreciate the seriousness of the offense. But I can't tell because there's no statute. It looks like that's what she's doing. And then she goes on for a few pages, sort of back and forth, ultimately ruling the sole reason, our position, the sole reason she rules that Mr. Abbott is denied probation when he is almost a perfect candidate for probation under the record of this case, almost a perfect candidate, is that although it's just hard to overcome, I cannot in good faith depreciate the seriousness of the sexual battery by a teacher at a school function after months of inappropriate relationship. This is an incorrect ruling under statutory and the common law of this state regarding a sentence. First off, if her sole reason is depreciate the seriousness of the offense under 40-5-103B, then she's got to go to the Trent Trotter heightened scrutiny and say, okay, the crime is an exceptional type crime. It's violent, it's heinous, it's cruel, whatever under those cases. Or even under Judge Greenholz's decision in Frazier, he goes through that analysis. However, she doesn't do that. In fact, at page 88, she says they don't exist and comes up with this idea that the depreciation of the seriousness of the offense is that he's a school teacher. Your Honor, I know you all know this, but sexual battery by an authority figure is just, the paradigmical charge of sexual offense by authority figure is a school teacher. That's taking the actual elements of the offense, and I don't need to read that out to you, and using it against him, as Trent says you cannot do for sentencing. He's already pled to the top crime he can plead to. He's not depreciating the seriousness, and the statute itself encompasses that seriousness in it. He's not pleading to sexual battery, which is 2 levels lower, and he's not pleading to sexual contact, which is an A misdemeanor by an authority figure. So what's happened is Judge Ayers is right. She goes through all the probation. She goes through the motions of going through all the reasons that Mr. Abbott qualifies for probation and is especially good at probation. She never weighs. She uses her heart instead of the law on page 91.
Does the trial court ever say, or is that your characterization, the sole reason was the seriousness of the offense?
That is my characterization from the record, Your Honor. It is I'll say this to answer your question in more full. On page 88 at the top, and if we recall, and I know you all do, TCA 40-5-103B encompasses really 2 factors, and the other one is deterrence to others as a factor. On page 88, she mentions it's not okay for a teacher to commit a sexual battery on a child, on a student. It's not, and that needs to be known within the community, within this state. And so if that's an effective deterrent, if that's a consideration to be made, then that's what it allows. Your Honor, that's not a finding. That's a comment on the section. That's a comment on the case maybe, but that's inherent in the statute.
Tell me how the statement that you led your argument with has nothing to do with general deterrence.
Tell me that the
statement I think you read it twice.
Yeah, it's page 91. It's what we believe is her sole reason. She doesn't mention deterrence there. She does in defense trial court, in defense of the sentence. She mentions deterrence very briefly on page 90. But this is what she says, Your Honor. I cannot, in good faith, depreciate the seriousness of the sexual battery by a teacher at a school.
Well, what about on page 90 when she says, I have a defendant sitting before me that has complied with pretrial release. That is somewhat favorable. I say somewhat because low to moderate risk is still risk assessments, but weighing that against the seriousness of the offense, the weight of providing an effective deterrent. And then she goes on to say, I can understand that everybody loses, and then goes on to say the part that you've been discussing about that she can't in good faith depreciate the seriousness of the sexual battery by a teacher. I mean, that to me sounds like weighing those favorable factors and making
the trial court, as Your Honor knows, is not bound to the exact wording. I mean, there's some ways to take a record like this and say, you know, did she consider it or not, or did she word it or not correctly? Our position is page 91 reflects her ruling. It reflects the sole reason.
But it's
She
really
goes-
a very lengthy ruling, isn't it? I mean, she goes, it's very lengthy. She goes on, and you can tell the trial court's struggling and tells everybody, I'm struggling with this difficult decision, and really spends a lot of time talking about the struggle and the issues and the points that she's weighing.
But Judge Harris, she doesn't
And
function.
so we have to review this for abuse of discretion. And it seems like she really spent a lot of time working through those factors and weighing them.
And let me add to that, because you just said it. I mean, the law doesn't require the trial judge to quote chapter and verse and go by the statute as he or she is ruling. It is, yes, they have to make certain findings, of course, but you said they don't have to quote it perfectly, right? And so when we're looking at this lengthy ruling and looking at it as for abuse of discretion, it seems pretty clear, potentially, that in this, she went through all the analysis she was supposed to go through, and you're focusing on one sentence, and I understand why. You're focusing on one or two sentences at the very end, but that's not really her entire ruling. Her entire ruling is the 20 pages or whatever it is. That's her ruling, is it not?
Your Honor, well, length of a ruling does not make it stronger, Your Honor.
That's not my point. I'm saying we have to look at the whole thing. It's not just one sentence. We have to look at the whole analysis that she conducted, and I think that's what Judge Ayers is talking about. It's clear as you go through, as you read it, that she went through, Judge Ayers said struggle, but also you can be an analysis here, right? And you're hyper-focused on the last two or three sentences, whatever that is, and almost discounting. I mean, Judge Ayers just read it. I have to weigh this. I have to consider that. That's part of her ruling.
Well, Your Honor, she doesn't follow the statutory scheme in doing that. I know she doesn't have to mention it verbatim, but what is she doing? What is the exact reason she's denying probation to Mr. Abbott? And it's clear as a bell that page 91 reflects that. Now, I see what you're saying. She is considering things, but she's not following the statutory scheme. She's not giving enough weight to Mr. Abbott's favorable probation. She doesn't ever find that in the first place. She's not ever weighing the ultimate pro and con. She says she's weighing individual factors, and she's stuck on depreciation of seriousness of the offense. After reading this a million times, and I know no one else is going to do that, this is the problem with this rule.
So your argument, part of your argument, as I understand it, and I want you to correct me if I'm misinterpreting it, is because he's a teacher, and that we can't take that part into account when we're talking about appreciating the seriousness of the offense, because he was an authority figure, he was a teacher. We can't take that into account in determining whether or not we need depreciating the seriousness of the offense. Is that your argument?
Well, if my argument is, if that's the sole factor she relies on, and she appears to do that, not just here, but throughout her ruling, then she has not, well, she did conduct the heightened standard and said that does not exist here. So she falls back to the fact he's a school teacher, and the fact that he's a school teacher is already part of the element of the offense, which Trent says we shouldn't use at sentencing. So then that would not be a legal sentence here. Now, that sounds convoluted, but it really isn't. Because if she's finding depreciating the seriousness of the offense as her sole reason, she's not conducted a proper Trent Trotter analysis. She's not found the heightened standard. And he is a prima example of somebody that is a perfect person candidate for probation. And so when you talk about weighing things,
are you saying that someone who has no criminal record and, as you say, is the perfect candidate on paper for probation can never be denied probation based on not only depreciating the seriousness of the offense, but she mentions the circumstances of the offense. So are you saying that those two factors can never outweigh the positive factors?
no, there's always a way something can outweigh something. And I don't agree that a de novo review can't be raised in this. I don't think she followed the sentencing principles of sentencing. I don't want to add that before my time runs out. But Judge Ayers, She never conducts that total balance. And in fact, when she discusses depreciation of seriousness of offense, she uses the fact that he's a school teacher, but not the heightened standard under Trenton Trotter. So in this particular case, I would say that denial of the probation for Mr. Abbott was an abuse of discretion and or was a misapplication of the principles of sentencing and then a legal sentence that you can review de novo, which, I'm running out of time, we'd ask this court to sentence de novo Mr. Abbott or remand for resentencing, of course. We don't have the same problem that you had in Frazier here. It's a little different. And I agree, there's some consideration of some of the factors, but you can't just do lip service to the consideration and then conclude at the end, the ultimate reason is this, and that's just because, in my good faith, I just can't do it. Thank you, Your Honor.
Thank you. General Coleman, you pinch hitting again this morning?
Yes, Your Honor. Good morning, Your Honors, and may it please the court. Ronald Coleman on behalf of the state here for Ryan Dugan, who has taken his talents to the Missouri Attorney General's office, and their fortune is our misfavor. But to this case, this court should affirm the judgments because the trial court properly exercised its discretion in denying alternative sentencing. I don't want to belabor the points too much because this court seems to have hit the nail on the head repeatedly, but I do want to point out the factual background before we dive into the analysis itself, because this is a pretty serious offense, and I think for those watching here on YouTube, they need to know exactly what this defendant did and why he's not a perfect candidate for probation.
If you will make sure you use initials while
Not
you're
even
doing
going to
that.
use initials, going to just call her the victim.
Thank you.
So after the defendant met the victim when she was in 7th grade, while he was a teacher, he engaged in a pattern of romantic pursuit that ultimately escalated to him repeatedly sexually abusing her, going so far as to kiss the young girl's breast and force her to touch his penis multiple times. For his conduct, he agreed to plead guilty to 2 counts of sexual battery by an authority figure in exchange for a 6-year sentence, with the manner of service left to be determined by the trial court. And I think we need to get to what was discussed at the sentencing hearing. It seems this court might have already seen the sentencing transcript. The trial court makes roughly 20 pages of findings. In those findings, the court goes through the factors and considerations that it has made. And then it emphasizes that it emphasized the length of time that the inappropriate conduct had gone on, as well as the fact that the defendant had refused to adhere to 2 earlier warnings. He'd been warned twice by the school not to continue contacting the victim, and he continued to do so. So the court emphasized that this had gone on for roughly 2 years and that the defendant refused to learn from those earlier warnings. The court found that the location of the offenses was highly relevant to both deterrence and appreciating the seriousness of the offense. It explicitly noted the defendant's lack of criminal history and his compliance with pretrial release, but it gave extremely heavy weight to the factors of deterrence and appreciating the seriousness of defense.
Was there anything in the record, sorry,
Keep going.
that specifically talked about deterrence? You know, I mean, you can't just give lip service and say, I want to deter. Was there any, more details about this type of crime, how it needed to be deterred, what was going to happen?
And so the majority of the discussion is on pages 87. The bottom of page 87 to page 88, the defendant, my friend on the other side, referenced the top of page 88. But it's clear that at the bottom of page 87, the trial court is explicitly considering deterrence and the deterrent effect. So just the last paragraph. Whether or not confinement is particularly suited to provide an effective deterrent to others likely to commit similar offenses. I think that's something that the court has to consider and weigh heavily, weigh extremely heavily. It's not okay for a teacher to commit a sexual battery on a child, on a student. It's not. And that needs to be known within this community. So the court, I respectfully, I'm going to disagree with the characterizations of the court sort of going through the motions or giving lip service, which are quotes that I heard today.
What about the argument that the fact that he's a teacher is part of the element of the crime? How does that impact our analysis?
I don't think it does, because the court went further. The court didn't just say this is a teacher. Again, it emphasized the location. It emphasized the length of this relationship. So it's not just the statutory element that he was in a position of authority. It was also that he'd continued to do this for 2 years after repeated warnings, and that it was at the school, or at the school and on a school field trip. So the deterrent effect, the court was allowed to consider that with those additional factors. And so because the court did, I want to make sure I discuss this, that the defendant cites to Trotter and has repeatedly argued before this court today that the only factor considered was depreciating the seriousness of the offense, and that is simply incorrect. The court very clearly, very explicitly considered the deterrent effect, not only the specific deterrence on this defendant who ignored 2 prior warnings from the school, but also the general deterrence for other individuals in positions where these vulnerable children are stuck for hours a day. That's a reasonable finding. The court also did consider the depreciating the seriousness of the offense, and confinement was reasonable under that factor as well. Again, the defendant engaged in a 2-year-long relationship with the minor victim. The court was allowed to make a strong point emphasizing the need to prevent grooming. And again, the court weighed those 2 factors against the factors that benefited the defendant. This wasn't just you did something bad, you go to jail. As you noted, Judge Ayers, the court was clearly struggling, was pointing out the benefits of both sides, or the factors that weigh in each side. It explicitly noted that the defendant did not have a criminal history. It explicitly noted that he'd complied with the conditions of pretrial release. It sort of split the baby with the potential for rehabilitation, noting that it was a low to moderate risk, but it was still a risk that he might reoffend. And then it weighed heavily, again, to quote the court, weighed extremely heavily both the need for deterrence, general and specific, and the seriousness of the offense. If this 20-page ruling of the court, which, again, to your point, Judge Dyer, this court needs to consider the entirety of the court's findings.
And I obviously agree with that statement because I made it, but also at the same time, though, I mean, when we look at a ruling like this, it is natural, it is normal for us to take the last 2 or 3 sentences and say, this is their ruling, correct? I mean, this is the conclusion. They've gone through all this, and here's their conclusion, right?
I think it's certainly the conclusion, and
if that's the case, and all she says in that, quote, conclusion is depreciating the seriousness of the offense, how do we weigh that? How do we weigh that versus everything else she said if, according to them, she didn't do everything she was supposed to as far as that analysis?
The court did do everything she was supposed to do, and this court can look at that final finding, and what it means is that is the factor that the court is placing the most weight on. That doesn't mean it's the only factor that she's placing weight on. And again, when you're viewing it in the context of her entire finding, it makes sense why she did that. She's weighed factors in favor of the defendant, weighed factors against him, and then ultimately concluded and said this factor is the most important. This is what is really, weighing heavily on me. But that doesn't invalidate her additional findings about deterrence and, again, the factors in the defendant's favor. I don't want to belabor the point. The state submits that these findings are more than thorough and overwhelmingly sufficient for the abuse of discretion standard to apply, and under that standard, this court should find that the court properly exercised its discretion. If there are no further questions, we ask you affirm.
Thank you.
I don't even think I'll need my 5 minutes, actually, Your Honors. I think, in disagreement with the state, the 3 counts that he agreed to plead to and that he pled to covered the course of conduct in this. Those are 3 counts of sexual battery by an authority figure. That's the conduct. The mention about a 2-year relationship, that was not relied on by the trial court. What was relied on or mentioned by the trial court at one point in the sentencing was that he had been contacted, but he had communicated with this student on sort of a school-wide communication thing that they didn't like him to do. He got cautioned against doing that, and he did not listen to that. Now, was there a precursor to the physical conduct that he pled guilty to? Probably so, like casing a bank. He was, there was something else there. There's no doubt about it.
Grooming is a little more than casing a bank.
Well,
let's not.
I don't want to depreciate the seriousness.
Let's not insult the victim or the crime here. Grooming is a lot more than casing a bank before you rob it.
But what actions he conducted beforehand were not part of the criminal conduct agreed to by the state and the defense, or the stipulation of facts. What part of the conduct she was able to rely on partly was this communication he had, and she did rely in part on that.
But that was in the record at the sentencing hearing. Yes, that information?
that
So
there was some prior discussion, there was some prior issue as to that in the record, but not stipulated to by the parties. And she doesn't go into any detail about it except to say he had notice and was determined not to pay attention to the
But the
notice.
court can consider that in sentencing.
Yes, and I think, I'm not, judges, I'm not saying that she didn't consider things. I mean,
Okay.
she goes through all these pages, and she does talk about these things, pro and con. What we're saying is, ultimately, she makes a decision to deny him probation based on one factor, which she earlier determined did not have that heightened scrutiny under Trent and Trotter, and she finds that factor based on he's a school teacher, and this is at the school. Now, and I did not mean to depreciate the seriousness of the offense here, Your Honor, but she doesn't make the correct ruling at that point. And there's no other finding of deterrence under that B section. And on top of that, if you say the school teacher itself is enough to deny someone's probation, you're not, I don't think that's what she did. She's not making a blanket rule, but it does kind of serve as one if the school teacher and that status itself is sufficient to deny a school teacher who commits this crime probation as at least a consideration. And what's happened here is she's using it happened at the school, and she's a school teacher, and in good faith, she just can't let this go. That's the argument. That's the argument that we're trying to make ultimately, because she doesn't ever find, even with the facts the state recited in the record, she never finds that the Trent Trotter exceptional crime for this crime occurs, those atrocious, cruel, heinous factors. She, in fact, finds that does not exist on page 88. So that's our argument. It's maybe simpler, maybe it's too simple, but the length of the record does not, the complexity of her back and forth does not give her an out on failing to follow the principles of sentencing the state. Thank you, Your Honor.
Thank you. Appreciate your argument, both of you. Thank you very much.
Thank you, Your Honor.
Call the next case, please.